watching BloombergQuint. This is on the big story of the day. In fact, probably the big story of the decade, the Tata Mistry battle. Well, as you know, Cyrus Mistry and his investment companies had first initially lost at the National Company Law Tribunal, but today they've scored a victory at the National Company Law Appellate Tribunal, and that is to say that Mr. Mistry's dismissal as executive chairman of Tata Sons, the group holding company, has been reversed by the NCLAT. The NCLAT held that decision, or the board meeting that held that decision, as illegal, and has not only restored Cyrus Mistry to the chairmanship of Tata Sons, but also restored all of his directorships at various Tata Group companies. The NCLAT has also held as illegal the decision or the move from being a public company to a private company by Tata Sons. Now, this is a fairly sweeping victory for Cyrus Mistry, but it's not all going to be effected immediately. So tomorrow morning, Cyrus Mistry does not go back to being the executive chairman of Tata Sons. To understand this order better and the operationalization of the order, I'm joined by a very important person today, Somasekhar Sundaresan. He's the counsel for Cyrus Mistry and his companies that were fighting this case. Som, thank you very much for joining us. My first couple of questions is on the operative part of the order, and then we'll talk about the implementation of this order or how it gets operationalized from here on. You've won on every single ground. You had sought to argue that the dismissal of Mr. Mistry was illegal, that there was oppression and mismanagement at Tata Sons, and subsequent to that, therefore, the restoration of his position was a must. Have I understood that correctly?
I didn't get the last bit.
Sorry, Som, can you hear me? I said you all argued in court that the decision to dismiss Cyrus Mistry was illegal, and that there was oppression and mismanagement at Tata Sons, and that the shift from a public company to a private company was also illegal, and you've won on all of these grounds.
Yeah, that's correct.
Okay.
That's correct.
Interestingly, the NCLAT decision says, and on several grounds, and I'm just trying to get a little bit of the flavor of the decision from you before I talk about the operationalization of this decision. They have said that, and they've pointed to the very fact that the Nomination and Remuneration Committee had just 4 months before his dismissal found Mr. Mistry's performance to be excellent as executive chairmanship, that there was no case or no suggestion or discussion of any of the accusations that was subsequently made against Mr. Mistry. None of these were discussed prior to his dismissal, nor were they brought to the board prior to his dismissal, and that 3 of the many directors that in fact voted in favor of his dismissal had only been appointed a short while before.
Yeah, that's correct. That was the real crux of what was argued. It was not really a dispute for reoccupation of office. The issue really was for the illegal nature of conduct of the governance of the company. You can't have a board instrument which essentially is the Nomination and Remuneration Committee, which logs the performance and the board accepts it, and within weeks it's minded without reason and says you lost the confidence. So the arbitrariness of it in running a company that was under attack in the rather than the craving for an office. So therefore, that part being vindicated is a welcome measure for us.
You made an important point, Som, that Mr. Mistry was not seeking to return as executive chairman of Tata Sons. So can you explain to us really what will be the outcome of this order? They have restored his chairmanship. They have also stayed it subsequently for a period of 4 weeks. What does this all mean?
Well, on the limited issue of whether he gets reinstated as an executive chairman, a stay has been granted for 4 weeks. It is clearly evident from both sides that he was not seeking reinstatement in office. But I think what happened is that the courts found the entire conduct so perverse that they have restored status quo ante. That is to say, they put the company back in the position it was in before these actions were initiated on the 24th of October 2016. So essentially that's part of the outcome. In any case, as you remember, he had a residual tenure of just a few months at that time, and it is a lack of grace in which it was handled that really underlined the arbitrariness of that conduct. So it's not as if he would be desirous to go back as an executive chairman, or the operationalization of the order, practically speaking, is not something that would work even at his desire in terms of a reinstatement in office. The key question is a board representation for the other shareholder in the company, which is the group, and that part has not been stayed. So therefore, the real question is not about the executive chairmanship. That's not being disturbed overnight anyway. But to put the minority shareholder back in the position it was in before this whole saga started is the real outcome in these proceedings.
So, Som, if I remember correctly, because these events date back to 2016 and 17, Mr. Mistry had voluntarily stepped off some of the Tata Group company boards, and when it came to the Tata Sons board, he had been voted out. Now, with this order, does he automatically get restored to directorships, which is that tomorrow, if a board meeting were to be called of Tata Sons or any of the other Tata Group companies that he earlier used to be a director of, would he now still be a director thanks to this order?
The position is, as far as Sons is concerned, the order is that he is restored as a director, or the minority shareholder gets a directorship. And therefore, if you are restored to the original position, the removal as a director was only a consequence of a removal as executive chairman. Therefore, the order essentially puts him back in the board. Whether he'd want to be a chairman or not is his sovereign decision. That's a call he will take. And we've said that we're really not craving for that office. But for the substantial shareholder of 18% to not even represent the board was an oppressive act. And that reinstatement is not stayed.
So I'm correct in understanding that hypothetically, if a board meeting of Tata Sons were to be called tomorrow, Mr. Mistry, by virtue of this order, would be able to attend that board meeting as director?
That would be the position in law.
That would be the position in law. And that would apply to the various other boards of the other Tata Group companies as well, where he was director and he had either stepped down or had been asked to go, by virtue of the events that took place in October 2016.
Look, I'm still in the process of reading the order. I've not seen whether this also applies to the other companies. I do know that this specifically was a ruling in relation to the holding company, which is Tata Sons. But I'm not sure if the same
I can read
outcome.
it for you. I did speed read it today, so I'll read it for you because I know you're in transit. In the result, Mr. Cyrus Mistry is restored to his original position as Executive Chairman of Tata Sons Limited and consequently as Director of the Tata Companies for the rest of the tenure. That's what the NCLAT judgment says. So I assume that includes all other group companies on which he was already Director at that point in time.
That's correct, yeah.
All right, fair. The next question I wanted to ask you was the outcome of Tata Sons being restored to public company status. The NCLAT has said that as of today or as of now, on the Registrar of Companies registrar, it will no longer be a private company, it will be a public company. That means as we stand today, Tata Sons has been restored to public company status?
That's correct.
Okay. What is the gain for Cyrus Mistry or any of the minority shareholders from such a move? Can you explain to me why this is a good outcome for your side?
Frankly, that is one of the most vital facets of these proceedings. The governance standard for a public company is much better under company law as compared to the governance standard for
yeah, so I think the line's not very good. So may I ask you to repeat that? What do you gain from this conversion of private to public?
Yeah, I was saying that the real heart proceedings is the issue. This is one of the most important facets of the proceedings. Public company and law are far superior to the governance standards for a private limited company.
Correct.
So for a public limited company, the law requires a far greater accountability and oversight by an effective board as compared to a private limited company. This also has far-reaching external implications. In fact, the whole insurance sector was in jeopardy because the monies that had been lent to a public limited company suddenly became monies that are lent to a private limited company, and that inflicted a lot of costs and losses because those debentures and that debt had to be offloaded or repaid. And therefore, this restoration is a very important measure from the governance standpoint. The very fact that a private limited company is lightly governed as compared to a public company is what you see manifesting in the insurance law, which says an insurer must not subscribe to securities and debentures of a private limited company. So this is a very, very important development. It's a very important facet of the challenge that was involved in these proceedings.
I know you made it clear that this was not central to the case, but I do also understand, from my understanding of company law, that there are restrictions on the sale of shares of members of a private listed company versus public listed company, and therefore this reversal of status for Tata Sons will also be beneficial for a shareholder like Mr. Cyrus Mistry, even though I'm not suggesting he's in any interest or hurry to sell one or two or any of his shares.
That could be a consequential fallout. That's not the driver, but this was a very important facet, is what I said,
right,
from a governance point of view. Because the governance of a public limited company,
I understand that. Yeah, I understand governance, disclosure levels, filing requirements, all of that are very different for public limited companies versus private companies. But I also understand that certain shareholder rights are different for public companies versus private companies, and therefore this also goes in favor of Mr. Mistry. Is that correct?
Yeah, all shareholders. Yeah, that's true.
All shareholders, but here we're talking about minority shareholders and not Tata Trust, because they've not had any reason to complain. The next point was about the case of oppression and mismanagement that you all brought against Tata Sons, which again has succeeded at the NCLAT. Now, what does the outcome mean for you? Having proved that there was oppression and mismanagement, is there anything else that comes out of this decision?
Well, multiple counts, apart from the fact that it's been an important watershed event for governance of an important institution. We're talking about a systemically important financial institution. It's a SIFI. And the governance of a SIFI is very vital and has come to the fore in recent times, as you see other SIFIs which are going through serious governance-related proceedings. So that's the most important element. And of course, at a personal level, it's also cathartic to be vindicated for having been wronged and that being articulated well in an appellate decision.
No, that's fair. So I understand that you've been vindicated, or Mr. Mistry's stand has been vindicated, that there was oppression and mismanagement. But what is the benefit of having proved that? Is there any material benefit of having proved that?
Substantially. The future chairman shouldn't undergo the treatment he underwent. Is a very important gain.
Sorry, could you repeat that for me? My apologies, but could you repeat that for me?
Future chairman shouldn't undergo what he underwent.
Okay.
That's a very, very important development in the history and life of any institution.
Okay.
And governance is at the heart of all of this. I mean, if the governance of a company can be arbitrary, despite being a SIFI, and you get a declaration that such conduct is not in consonance with law, it's a very, very important watershed for tenure protection, effective governance, effective administration in the hands of future chief executives of the company.
All right, fine. So you're saying it sets a standard of sorts. There's one more observation that the NCLAT has made, and I wonder if this is a restraint of sorts on the powers of Tata Trusts, which are the majority shareholders of Tata Sons. It is said that Ratan N. Tata and the nominee of Tata Trust, these are the nominee directors that Tata Trust nominates to sit on the board of Tata Sons. So Mr. Ratan Tata and the nominee of Tata Trust shall desist from taking any decision in advance which requires majority decision of the board of directors of Tata Sons or in the annual general company. This seems like some sort of restraint on the ability of the nominee directors or even the Tata Trust people, including Mr. Tata, to pre-approve any decision that is going to come in front of the Tata Sons board. Can you explain this to us?
In simple terms, the grouse at the heart of this issue was about extra constitutional authority being wielded on the functioning of the board governance. If the decisions about a company are all taken in advance outside and they merely run through the motions of a board approval, that's what's been barred. So what it essentially means is don't just use the board as a formal instrumentality without the board actually being the governing foundation for the governance of a company. So regardless of whether there's a board, it isn't taken outside. The fine balance created in law between the shareholder and the powers of the board that was disrupted. So that isn't part of this relief.
So this is consequent to the arguments you all made that there was considerable, maybe interference is not the right way, but pre-approval required from Tata Trust officials, including Mr. Tata, before decisions could be considered and decided upon by the Tata Sons board. This is in response to that?
That's correct. So loosely speaking, we could call it interference, pre-consultation, degrees of how benign or horrible you want to picture it. These are the phrases used on both sides. But essentially what this relief underlines is that the governance of a board rests in the office of the directors of a company.
Okay, for our viewers' sake, I also do want to point out that the NCLAT has criticized some of the language used by the NCLT in its order. Some of this language was frivolous and seemed to be slanted against Mr. Mistry, and they have made a point to critique that language in this order. But, that's not material from the outcome point of view, just requiring a mention. Having said that, Som, I just do want to sum up that it is very clear to us that, Tata Sons will seek to appeal this decision at the Supreme Court level, and none of us know how that will turn out, whether that will go in your favor or in the Tata Sons' favor. In the interim, between now and a Supreme Court decision, however long that takes, from what I can understand of what you've told me, the only thing Cyrus Mistry is probably seeking is a return of his directorships on the board of Tata Sons and other Tata Group companies, and that is something that he will hope to actualize as an outcome of this decision, if not stayed by the Supreme Court.
That's correct. I mean, you can't be a 20% owner in a company, and you are 20% owner with no insight. In a majoritarian governance, the minorities have a voice. The minorities can be outvoted, but they have a voice. But what happened in this scenario is, not only can the minorities be outvoted, minorities didn't even have a voice. So if you don't even get to know what the board is doing, despite owning 1/5 of a company, that's the remedy that's been obtained. So in the interim, having an insight into what's going on and contributing to the governance, that's the important part of this outcome. And of course, the other point which I said, which is the heart of ensuring that the board is the effective platform of governance and not forces outside the board.
So I'm going to ask you a question that you might not find comfortable to answer or might not be within your remit to answer, but I'll ask it nonetheless. Since October 2016, we have seen a new chairman now installed at Tata Sons, as you know, N. Chandrasekharan. This is going to be an uncomfortable moment for him, right? Not because his position is under threat. As we've already explained here, Mr. Mistry is not seeking to return as executive chairman. And anyways, that part of the order has been stayed. But he's returned to the board as a director of the board, despite the fact that he does have a significant shareholding. Will that be a difficult situation for the current board of Tata Sons to overcome in some way?
I don't think so. At the end of the day, these are commercial business people who acted emotionally and arbitrarily instead of reasonably and in a measured manner. So I don't see, businessmen are used to disputes and disputes having an outcome. I think the time is now ripe to sit back, do some introspection, and work harmoniously in the best interest of an institution, which, as I said, is as serious as a SIFI. It's a significantly, systemically important financial institution whose governance is at the heart of a good impact even on the system. So I think time is now to be constructive, work harmoniously, and examine how to make shareholder value and stakeholder value be protected and enhanced in a harmonious manner.
All right, so two big takeaways from this decision, notwithstanding what the NCLT has already said a year ago and notwithstanding what the Supreme Court may say anytime here on. And those two big decisions are that Cyrus Mistry's directorships on the board of Tata Sons and other Tata Group companies gets restored, and he will actualize that so as to be able to protect his shareholding in the parent company, which is Tata Sons. And the second big thing is you think this serves as a precedent for governance levels in companies and group structures similar to Tata Sons and other Tata Group companies, and you believe that the finding of oppression and mismanagement serves as a caution or a warning to other boards in how to better improve their, board procedures or processes, correct?
That's correct, yeah.
All right, I think I've summarized it correctly. So, appreciate you finding the time to speak with us today, and have a safe flight back home to Mumbai. Somasekhar Sundaresan there, the counsel for Cyrus Mistry, explaining to us not just the implications of this decision of the National Company Law Appellate Tribunal, but also the actualization. Now, there have been many questions through the course of the day today about, will Cyrus Mistry come back to Bombay House as the executive chairman of Tata Sons? And as you've heard Som explain, that is not what Mr. Mistry was seeking to do, and that's definitely not what's going to happen tomorrow morning. But his directorships, both the Tata Sons and other Tata Group companies, stand restored at the moment that this order was issued today, which, hypothetically means that if there was to be a board meeting tomorrow of Tata Sons, Mr. Mistry would be well within his right to attend. I'm not suggesting he's going to show up without any warning, but that is the legal outcome of this decision. While the NCLAT also found oppression and mismanagement, we're looking through the details of all of that and the kind of precedent it sets or serves for other boards and the way they should be governed. And they have also insisted that Tata Sons be reconverted to public company status immediately, and that has several other implications from the point of view of rights of shareholders, which differ from public to private companies, and issues of disclosure, etc., which also differ between the two categories. I hope we've been able to explain to you some of the key takeaways from this decision. We'll be delving into the fine print in a little bit more detail over the days to come, so stay tuned to BloombergQuint or www.bloombergquint.com for more on that. Thanks very much for watching.